Welcome and thanks for joining us on this Bristol Law Society webinar, part of our ongoing series that runs during the lunch times across a variety of things. And if you want to keep up to speed with which webinars are being presented each week, please do have a look at our website, which has recently been redone to make everything very easy to find there, so you can keep up to date with everything and sign up to the ones that interest you. So today we're going to be looking at legal technology and how that's assisting law firms in managing claims, particularly scale claims where there are a multitude of claimants in class actions, an area that's been growing in recent years. And I'm joined today by our panel. So we have Mark from Enecto Legal standing in for David, who is unfortunately unwell. Those of you that know David and saw his name on the attendees there will be surprised at his youthful good looks today by comparison to normal. It's not him, it's Mark. I'm also joined by Connor and Timo, who are from FinLegal, who are talking to us about technological advancements to help manage large claimant books. And also Neil Stockdale, who's joining us from Hugh James, where I understand, Neil, you are the man in charge of class actions.
Yes, I head up the group actions team. We've been with Hugh James since 1997, so I've seen a few changes over that time.
Fantastic. Well, a couple of housekeeping issues. We are recording this webinar, so it should be available to you at a later date should you wish to check back on any information. Slides wise, it's actually going to be more of a discussion piece, so you do need to pay attention rather than sit and wait for the slides to be distributed later. Unfortunately, yeah, I think some of us can fall victim to that sometimes, but this will be a discussion that we're going to take between the panels. Hopefully that should mean that it's more interesting than just being spoon-fed information and death by PowerPoint. So I'm looking forward to that as a nice change from formats that I've seen elsewhere. If you do have a question that comes to mind during the course of the webinar, please use the Q&A function. We'll be collecting questions at the end and asking those to our panelists. So please do make use of that function and we'll look to get to that at the end. And other than that, I think all that remains is for me to hand over to our panel, which you can see there on the screen, to begin the discussion and fill us in on all things technological to do with the group and class actions. Over to you, chaps.
Great. Thank you guys for joining us, and good afternoon, everybody. I'm Connor Goggin, obviously. I appreciate you guys joining us today. I'm just going to kick things off, send it over to Neil. Neil, can you give us, a breakdown of maybe some of the bigger challenges you've faced with working with large groups of claimants?
Yeah, of course. I sort of apologise. My picture, it looks about 20 years old. But and as I said earlier, I've been with Hugh James since 1997. So there we are. Look, that needs updating. Obviously, things have changed a lot in terms of how we deal with group actions, but the challenges, I think, are very much the same. The same sorts of things that we have to deal with. I mean, in the early days of my group action experience, building up a group, you'd hire a hotel or a village hall or something, get people together, get people to sign up and fill out questionnaires and handle things with Excel spreadsheets and mail merge letters and file checklists and things like that. And obviously, things have moved on considerably, but the challenges around dealing with the actions, I think, are exactly the same in many respects. Main challenge is just the numbers. It's just you've got the ability to be able to sign people up, deal with people at different stages, making sure that you're vetting your clients and they're meeting your criteria, making sure you're keeping people up to date. And this takes up a huge amount of resource that takes away from the ability to progress the generic case itself. So it's just that ability to deal with the large numbers, I think, and manage them and keep everybody up to date. The other things that I've seen over the years is the importance of the integrity of the group, making sure that your clients are who they say they are, and making sure they've actually got claims that do actually sit within your group. there's a very famous example of a US case where there was a class action relating to a female contraceptive drug, where they had multiple claimants who were inmates from a male prison who actually, I think, signed up to the claim and actually got paid out as well. So, you know, dealing with large groups, the challenges are the same, I think. You know, getting the trust of the group is key. You know, being able to historically meet with people more and you know, see the whites of their eyes and sort of talk them through things and gain their trust. I think that's, you know, that's a real challenge when you're dealing with a larger group, particularly when you've got aspects of that group that may have a slightly different agenda and a different viewpoint about how things should run. So I think those are the main things. I think the final thing, I suppose, is when you've got a large group of clients, you've also got potentially a large number of other solicitors involved, and that has its challenges, because you have disputes inevitably over who's going to be the lead solicitor, who's responsible, how in terms of cost sharing, who's going to pay for what, and you've got all those sort of commercial aspects that go with the collective actions, and you know, so all those things are not, you know, there's not much law in there really. They're logistical and some commercial aspects in there as to how you're going to run the case. So as I say, things have changed over the years, but I think that those challenges are all pretty much the same as they ever have been.
Do you have any specific ideas of a sense of what the client's headaches are experiencing, the client's headaches that they experience when dealing with firms that are working on large claim groups?
I think that a lot of it boils down to the client experience of being able to engage with the firm. You know, the real problem we have is that what the clients often sort of take one look at the retainer documents they receive for signing up to a group action and think, crikey, what is this, you know, and run for the hills. And I can understand that, and I think it's real frustration that lawyers have to put in as much information, as the complex information as they do in the retainer packs to cut clients off. You know, so we've found that typically in some of our environmental work, for example, that you're typically only getting a sort of a 10% sign up of even though you've got an area that's impacted by environmental blight, you're only getting sort of 10% or so people that are actually willing to sign up because they're frightened about the legal costs and so on, even though it's supposed to be a no-win, no-fee arrangement. You know, we dealt with a case relating to a sewage treatment works in near Twickenham a number of years ago, and we had 1,350 people involved in that, but it was the tip of the iceberg. There were tens of thousands of people living in that area. So I think that's one of the headaches that clients have, you know, that interaction with the firm and clear information about what their case is and how it's going to be funded, and keeping it simple.
And I think that kind of follows on from other products and services, Neil, as well. It's, you know, when I'm engaging with a service or purchasing a product or a service or something like that, how do I get that kind of legalese, for want of a better term, across to a client? There's always been a struggle, there, hasn't there? It's not just from a class actions or group claims point of view. It kind of transfers from other areas too.
No, yeah, I think you're absolutely right, Timo. I think part of the problem is, though, I suppose, is that if you're signing up to, I don't know, an Apple app or something, and you're thinking, well, it's going to cost me 50 quid or whatever, and I'll click the terms and conditions. Nobody reads them. We all know that. Yeah. That's fine, you know, on that kind of, but if someone is, you're saying to someone bring a legal action and there's lawyers involved, you know, people just associate lawyers and costs and fees. So are they going to click that box to say, yeah, I'm happy with this, without looking at the detail properly? Because and lawyers don't want people to do that either, because obviously that has potential issues then around when you come to deduct from client damages. You know, did that client properly consent to that? So there's all sorts of dangers. So I agree with you, but I think the dynamics are a little different.
So Neil, do you see some specific cost centers when it comes to processing group claims?
Yeah, I mean, I think it does depend on the action, to a certain extent, and obviously if you've got a claim that involves very significant disclosure elements, I mean that can be a big factor in cases. But for me, the real concern about cost centers is those that you're not going to recover anyway. So, if you're dealing with disclosure, if you win the case, you can probably recover the cost of that disclosure. But in terms of the signing up, vetting, and all those burn costs of cases that don't sign up, don't go anywhere, that's just cost. It's gone. It's off the bottom line. So, I think that's a concern for me, and something that I think that these sort of systems and automated processes should enable you to significantly reduce.
You mentioned you worried a little bit about making sure there was that personal relationship with claimants, specifically in large claimant groups, making sure they felt like a relationship was with the firm. Is that something you think there can be a bridge between that and using technology as a kind of a way to interact with claimants?
I think so. I mean, it is difficult. I think it's difficult to replace that sort of personal interaction, isn't it? I mean, these things are great, being able to communicate in this way, and there's also a real difference in the client base. Some people don't want to talk to you anymore. They're happy to deal with an email or just an automated process. Whereas, I think not everyone's the same. And I think, we need to be sensitive as well to the different types of cases that we deal with. And a low value claim relating to, I don't know, a financial case or something that was only cost that individual a small amount of money is one thing, compared with a very serious case that has real implications for that individual. I think the other thing that's difficult is that, if you don't know your clients very well, because they're all dealt with in this way, or you're directing them to be dealt with in an automated way, you don't know what's going on in their lives. I mean, I had a conversation the other day with a very vulnerable client who, it wasn't a big case. It was a solicitor. He was facing an adverse costs order, and it was a group action, and the amounts involved very small, but this guy had significant other issues in his life, and this was the straw that broke the camel's back. So it was massive for him, and really serious issues around that. So, and you just can't direct those kind of people to an app. So I think there needs to be ways of dealing. This is the way that we can deal with you, but we as a firm have got that kind of ability we need to deal with you slightly differently, or give us like a personal touch. So I'm not sure if that answers the question today.
That was great, Tim. I'd love to hear your opinion on kind of building a personal relationship with claimants, but also leveraging technology as well.
Yeah, so I think to build on Neil's point there, we always talk about kind of internally managing by exception. So if you can, from a claim group, if you can get 80% or whatever the number is through that kind of lightweight channel, then you're seeing that impact in terms of your costs and things being driven down. But you can't lose, and you've got to cater for and be inclusive of that remaining 20% as well. And that's where the face-to-faces, be it supported by technology or telephone or whatever it might be, is still important, and I don't think we can overlook that. And certainly as we build out products and services, we look to kind of include that section of society and users, if you like, as well. In terms of kind of building trust. I think it's about, for me, being able to present your firm out through that technology. So brand's a big piece. We certainly, you know, working with our customers, it's very important to them that we abide by their branding guidelines in all our points of communication. So be it through web channels, be it through email channels, or documentation. That's very important in terms of being able to present that kind of face of the firm out to the customer. Access, I think, you know, to the various channels which we've just discussed there, but also kind of transparency and update and information, which I think, you know, the likes of Neil and others do today. Technology kind of makes that easier. If I want to communicate an update on a case or a particular, you know, change in direction, then I can do that kind of in a matter of hours, if you like, versus days over a big client base. So, you know, I think those principles aren't new. In my opinion, it just, the technology allows us to do it much more effectively and efficiently, I think, in order to kind of maintain those pieces. I think the final point as well is, you know, how are we, a lot of this is based on data, you know, collecting data from users, from clients, processing that data in order to build that trust. Let's be transparent on what we are collecting, why we are collecting it, and how we're going to use it. And I think with that background, then you can start to develop that relationship and maintain that relationship with your clients.
So Neil, Timo, have either of you guys seen, you know, firms starting to address some of these issues? And if so, what's maybe driving the need for them to address these issues now and maybe over the past couple of years?
Yeah, I mean, I think that firms are addressing this. You see it from the various different platforms that have been used and the facilities that you have to sign up to different collective actions. And I think, you know, increasingly it has to be done, because I think that you're seeing defendants and the courts increasingly wary of granting group litigation order cases because of concern over cost. And I think those concerns can be addressed in this way. I mean, if you look at the number of group litigation orders that have been granted since they first came in 1999, around then 2000. I had a look this morning. There were in the first 5 years there were about 50, and in the last 5 years there's been about 6 or 7. You know, I think the rate, there are various reasons as to why, you know, there aren't any cases, but I think there's a pushback in granting group litigation order cases because defendants fight it, and because of the cost, and the courts have seen that they can lead to significant costs of managing groups. So I think moving forward, the courts have always allowed you time in your budgets for managing group action cases, and historically you'd get some, you know, an allowance to send out like circular letters and that kind of thing. But I think that's going to go, and I think courts are going to, when the court comes to approve a GLO, they're going to be looking at, right, well, what facility have you got for managing this group? And I think I haven't seen it yet, but how the cost of that is factored into your budgets and how that's going to work is going to be quite interesting. So I think, you know, I don't know what you think, Timo, but I think firms need to address it, because the courts know that technology exists, and they're going to expect to see it implemented. Yeah.
Yeah, I think it's only a matter of time. It feels like, you know, it's catching up within this industry. It always amazes me, because if I look at the technology we use within the FinLegal product, you know, it's very much what I would consider a kind of Web 2 technology, if you like. You know, it's capturing data, it's storing data, it's playing data back in various different ways. And actually, that technology has been around for, you know, 20 years, essentially. You know, it's not new AI stuff that we're talking about today. it's kind of what I would consider kind of stable, old, although still good technology. And it's what we're working through with, with others is applying that technology to managing these problems. So I think it's, it's getting there, and ultimately, sorry, it'll catch up. It'll catch up with us, and it'll be expected, I think, that it's used. And it's, the challenge is how then do firms kind of react to that? What do they do? And I think we're starting to see, certainly from our side, firms are looking, and I think, firms like yourself, what they can do and what their options are.
Well, I think, and firms, I mean, let's face it, your average law firm is going to be pretty slow to respond to movements in technology. Some firms are faster than others, obviously, but I think, for a firm like ours, I think, that there are challenges because you've got broad practice and different requirements across the business. So when you've got existing case management, time recording systems that are part of that firm's DNA and might have been for many years, it's difficult. I think the other difficult thing for firms looking to adopt this is, there are we've seen lots of different systems and understanding, how they work and what they offer, and it takes time. We've had many a presentation from different platforms as to what they can offer. And I think, as you know, Tim, as well, you've got some platforms will offer well, this deals with onboarding, this deals with disclosure, this deals with payments. Well, in a lawyer's head, they're thinking, well, I'm going to end up with 3-4 different systems here. How's that going to work? IT, going to love that. Training, going to love it.
It'd be interesting to know, actually, Neil, who you say you've been through a process there in terms of understanding and selection. Who led that? Who kind of championed that process from your firm's perspective? Was it an IT driven thing, or was it a kind of partner and business driven activity?
I think it has to be partner led. I pushed at this for some time because I don't think that it has to be the it's no good IT telling you what you need to do. We want to be able to do this as a firm of lawyers, and and I think the process of actually getting it done as well, it's not good enough for a partner to say, well, I want a system that can do this, and I'll go away and build it. That doesn't work. It's got to be an ongoing collaborative process from workflow through to the delivery at the end, and I think that's key. So I think it has to be partner led, really, but getting that time is not always easy.
And I think that goes, that answers to some extent, or maybe we can answer one of the questions that I think was raised before here, which talks about how do I make sure I've got the right technology, or I think that was one of them in there. Correct me if I'm wrong. And I think so that's part of it. I think it's having, don't let it be about the technology, let it be about what problems your firm wants to solve, really. What benefits you, or particular use cases you want to address is the kind of first and foremost, or should be first and foremost in any kind of list or process that you follow to understand what technology to use, essentially. I mean, moving on, it kind of so we're seeing different firms do different things. You mentioned their kind of IT departments building things out, Neil. I think there's still a lot of that, actually. They build things out, either bespoke solutions, so where they've got the resources within the organization, then they may kind of build out their own bespoke solution there. You mentioned at the top of this discussion also kind of the use of things we know and love today, like Microsoft. There are advances in that technology and that suite of products that people are more familiar with and have been for a number of years, that kind of allow you to automate processes and collect data and process that data and build workflows around that. I think then you come to the kind of the service led piece, if you like, which you've got vendors offering that software as a service that you can take either on a piecemeal basis and integrate it with your current solutions, or build your kind of core competency around that. So kind of that's what we're seeing right now, I think, from a kind of where firms are going to address these challenges.
Yeah, I mean, if we've built out various different things in-house, but it's a question then of the resource and the and the time, because I think getting these things up and running when you've got a new case type is important to gain a sort of competitive advantage. So it's a question of resource and the capability within a firm, I think, and that varies massively, obviously. Yeah,
and I think it's and also with the solution that you choose at the end, if speed to market or time to market is important for you for a particular case, then it's not necessarily just about the technology, but it's the configuration of that technology. If you've got to go and procure some developers, for example, to build on your peppermint system or whatever technology you're using today in house, you've got to factor that into the kind of end to end as well. Rather than the kind of the technology that people use day to day. So
and you were talking earlier on about it need to be partner led and that, because I mean if you try and build something out in house, that's great until there's you win a big tender or something else happens elsewhere in the business and they say actually no, resource IT is going to be directed here on this project, and you're left potentially not getting your platform up and running until it's too late potentially.
It's interesting actually, if I can share, one of the things we have noticed in some areas is kind of a hybrid of the two, where there's an internal IT team and there are other teams that use kind of partner provided solutions or supplier solutions, if you like, to achieve objectives. That's an interesting combination, and it's interesting to see how then the kind of the politics of that, if you like, fan out internally inside the firm as things progress, and the two solutions tend to compete. I'm not sure if you have that problem, Neil, but it's certainly been interesting in some areas to watch that unfold.
No, there's no problems here.
Cool.
If anyone tells you that about their business, they're lying. No, I think a collaborative approach is the way forward. I think and I think it's about sort of working out what you want at the beginning and deciding early on. Can we commit to delivering this? And if we can't, we need to find it needs to be done in a different way. So but I think that ability to get up and running quickly is important. Once, of course, you've properly considered the case, because you do see people because people don't look at legal directories when they come and sign up to a case. They just look at who's got the best fanciest website and the best fee. So they might have no pedigree at all in dealing with group actions, might not have actually risk assessed the case or sorted out funding or anything, but great website, I'll sign up with them.
That's kind of an interesting point as well, in terms of you talk about it being a great website. How important is that in terms of time to market? If we, I think typically or historically we've spun up sites, for want of a better term, in a matter of days at a client's request. But in order to do that as a service provider, we're using common platforms, we're using common components. Yes, we've talked about brand before, and that's important, and a firm always gets their brand on there. But these things are pretty much to some extent off the shelf and configured, and that puts us in a position where we can launch that. So I don't know, it'd be interesting to get your view on how important is that versus having something that's a little bit unique to Hugh James in this case for a particular case.
Well, I suppose you need to ask the clients, wouldn't you, really? I mean, I don't know what what gets the client to prefer one platform over another. But I think, you know, I think if you have got that brand and you have got that ability to say, we've done this, we understand these issues, you know, been around for an X number of years, then yeah, that's great, because that, you know, that is a differentiator, I suppose. But you know, on some of this stuff, you know, people are just not really concerned or going in that way at all. They'll be responding to something on Facebook that says, did you own a BMW, diesel BMW, and what's the registration, and and they don't care. Don't care. So it comes back to what we were talking about earlier about being sensitive to the nature of the type of case you're dealing with, I think. You know, and a case involving a community affected by a you know, a landfill site or something very different to someone signing up to a diesel emission case, because you know, it's not about their day-to-day life and what, you know, they're experiencing day in, day out. It's that, oh, okay, well, sign up to that because I think I might have been ripped off. So yeah, who knows what goes on in the mind of a client.
So
you can put yourself in that position, can't you, and think, well, what would I do?
So Neil, how do you balance, you know, putting together a website that, you know, shows off the value that you add and maybe looks a lot cleaner to give you a better look, and balancing that between, you know, we want to be the first to market, so we are the first one with a Facebook ad that person can see to click on. So what, you know, how do you weigh balancing those two things?
I think this is where lawyers are really bad at this, because they want to put in as much text and as much sort of detail and explanation as possible. So the way that we tend to do that kind of thing is we'll say to the lawyer, what do you want to say on that? What do you want it to say? And then we give it to the marketing people and internally, and we say, what would a client want to see? You change it. And it tends to go back and forth between the two until you get to something that makes sense. And then what we would typically do is say to somebody who knows nothing about it, read this. What do you think of this? Would this make you sign up? Does it give you the information you need? So that's the process. I'm not sure whether that answers the question, but that's the kind of process we go through, try and make sure it does the job.
And I think, you do, again, to add, it's that maybe we can borrow from that kind of product and software development mentality of agility in kind of case deployment. So what's the bare minimum? Let's work to get that built and out the door, and let's keep adding to it. You know, we've worked with clients that have changed their minds 3 or 4 times, and we, you know, as long as we've got the base or the core of the nub of the data collection and the legalities in there, then finessing the wider content and the flow, so long as it can be done easily and quickly, then you can learn from it, and you can learn you know, about how that takes, or how that impacts the funnel, if you like, of clients from start to end. So you got to look for those types of things in the solutions that you're engaging with to allow you to do that. And it's a kind of mentality shift as well, from a way of working point of view. You know, it's easy for us to say, I guess, because that's the world in which we live in terms of product development and software development, but that's different for different kind of industries.
I think that's fine. I think as long as the lawyers know that you know what they're getting, and that it will only go up to, you know, it might not deal with all the stages of the case, but it goes up to here, and then we take stock and we do the rest of it. I think that's fine.
Yeah.
So, Neil, do you find the same things? You know, we talked about retail claims, but do you find the same issues are happening in terms of B2B claims and things like that, in terms of issues and dealing with claimants in large groups?
It's exactly the same, really. I don't see that. We do a fair amount of business claim, selling type claims and insurance kind of work, and you know, when you're dealing with a collective case type, I don't, to a certain extent, it doesn't really matter whether it's an individual or a business. Obviously, the due diligence is slightly different about, you're making sure that you know who you're acting for in terms of the company, and whether the person's got authority to bind the business and all that kind of stuff, and your due diligence checks. But yeah, I think the process, there's no reason why businesses can't benefit from these platforms in the same way that an individual claimant would. I don't know what has that been others' experience? I mean, I don't know whether.
Yeah, I think from from my perspective, that the solution elements are the same. You're dealing with, you're identifying prospects essentially, and there's a set of solution elements that look at that, and being able to kind of take that data in and process that data. You are kind of reaching out to those individuals, be it kind of individual on a retail perspective or B2B, and the solution elements that we look at there around web-based technologies, use on mobile, allow us to be inclusive of those, irrespective of case or claim type there. Capture of data again. Sorry, I thought the screen share dropped there. Capture of data again, it's the same types of things. We can capture the data from the client, from the end user. We can, you talk about validation of that data, be it identity, be it vehicle information, be it company information with Companies House. That's how we those components are there to stitch together, if you like, and ensure that the validity and the integrity and accuracy of the data that we're collecting and processing. And then we look at kind of reporting and management. So, irrespective of claim, these capabilities or these elements are available to kind of report upon where claimants or groups of claimants or clients are at in the process, and being able to kind of manage them through, be it move them through a predefined workflow automatically, or flag for further human attention, if you like. So yeah, I think from my point of view, they're transferable elements, and I think we've grown up around class action, and we're starting to kind of look now how we transfer those across to the different claim types.
And this can be for David, Neil, as well as Mark. But when firms have adopted all this technology, how does the competitive landscape change between firms, and what do the differentiators become?
Who wants to take that one? I mean, from our point of view, I think it's difficult, isn't it? Because I think if everyone's on the same technology, then I think it is about those personal touches, and about, as we were talking about earlier, the branding and the ability to show why your firm is the better choice. So I think the ability to handle numbers once people have adopted this, clients will almost take it as read that people firms are going to be able to do this. So I don't know what others think.
I'd just add in there, I think it's difficult for us from our position. Obviously, we broker litigation funding, ATE insurance. So a big thing we talk about is, from the outset, thinking about what kind of structures you might use, and then how that can be simplified as far as possible, and then conveying that simple message out to clients. So I agree with Neil, really, from a technological point of view. I think it might be difficult for clients interacting via a web or some kind of portal to know who's got the best technology, but what they will be doing is making decisions based around how simple the sign-up process is, whether it's something they can understand, what kind of pricing differentials there are, and as Neil quite rightly pointed out there, any kind of additional extras. So there might be a pure tech interface with really big groups, but most of what we see aren't those kind of enormous kind of opt-out style groups, or I suppose opt-in more relevantly for this kind of tech sign up. It is more, smaller groups, 12 to 36 kind of people that have been ripped off from a development project, or perhaps 20 to 50 businesses that have experienced a loss from some kind of activity. And that's really about getting out in front of people and talking to them about what your process is, why it's a good one to work through. And then remembering that if you're engaging to some degree with individuals, but certainly with businesses, is that your sale to them, they might then have a forwarding on sale to do themselves, whether it be to their partners or family, or from a business point of view to their C-suite. So you have to give them the toolkit to be able to make that sale internally very simple. So they need to understand in very simple terms, you know, what is the case here that you're seeking to bring? What are going to be the costs to them or potential risks to them of doing so? And as Neil's mentioned a couple of times, there's not really much benefit at that stage in providing people with reams of information and real detail. What they need is some headlines, that kind of elevator pitch, if you like, to pass on to other people and really create kind of a simple process for them. So I come back to, you know, where we sit is very much around the kind of retainer, the funding, the insurance, and thinking about how that can be constructed to aid in that message being kept simple, really.
How have you found that kind of group interaction being augmented by technology, Mark? Have you, you know, you talk about kind of having the information at hand and being able to distribute that, but has it gone any further than that in terms of engaging with small groups? Or
it's in all honesty, Timo, it's difficult for us to say. You know, we're a broker, so we sit between the kind of, sometimes between the clients and the solicitor, but more often than not between the solicitor and the funders and the insurers.
Yeah.
So, you know, from a funding and insurance point of view, what you really want to know is that your solicitor has a good control over the group, has a good way of managing that and keeping progress going and keeping everyone updated.
Yeah.
And certainly from a funding and insurance point of view, you know, has a good decision-making process in place, that whether that's with individuals or businesses or with some kind of centralized committee that can make decisions to move the group forward. They're the things that you're really interested in. If that can be aided by technology, then all the better. And certainly from a funding perspective, you know, understanding budgets, where money's being spent, what's recoverable and what's not recoverable. These are issues that people discuss from the outset. So anything that, number one, kind of controls costs, but number two, can give some element of, if not certainty, then potential predictability around future costs is really, really helpful. So if you've got some kind of scalable onboarding system where, you know, as the group increases, there are marginal increases in cost in managing the group, that makes sense, because then you can think about, okay, well, the claimant, the value of the claim is going to rise as the costs are rising, hopefully in proportion. Whereas if there's just a huge upfront commitment to marketing and onboarding, regardless of what the actual size of the group ends up being, that's a lot difficult to fund and to budget for.
Got you. Yeah.
I don't know if you'd have anything to add there, Neil. I mean, sure, you've had experiences interacting with, you know, potential underwriters who've no doubt had these conversations at some length with you.
Yeah, I mean, I'll be honest with you, historically, you, James, have had very limited involvement with funders. We've self-funded a lot of litigation, but increasingly, you know, those discussions are taking place, and in terms of stuff moving forward. And I mean, the way that I see it, I suppose, is that funders, this is you know, expect to see this, and expect to see this technology being used and these systems being available. You know, and for that to be costed into the proposal, because without it, you can't really put forward a good case as to how you're going to be able to deal with the cases. You'd be back to my original sort of file checklists and Excel spreadsheets and that sort of thing, which I don't think is going to go down very well now in the modern day. What we haven't yet, you know, you talked just briefly there about the committees, you know, the management committees that might exist on these cases, and I mean, that happens. Does it outside of these platforms, or how what should be your experience of that? Because historically, what we've done is we've had the bulk of people on our case management system, but then they would say, okay, we're going to appoint these 10 people to be the conduit for, you know, for provision of instructions and in some cases authority to settle and things like that. So how's that handled?
So from my perspective, it's off platform right now, Neil. I guess
Right,
you know, the extent of platform is kind of CRM, as you touched upon there. So we might know, or we might be able to offer kind of a collection of relationships for individuals or entities, organizations that are involved in a particular thing. But today, any kind of communication is off platform, yeah, save for you know, save for direct communication, between platform and those individuals. That's why I was interested to understand if you've seen any evidence of, you know, we day to day in our well, maybe you don't, I don't know, but you know, there's WhatsApp, there's you know, Discord, there's a whole genre of communication platforms, if you like, that are starting to be integrated by businesses, you know, in retail, in other industries, to facilitate those discussions with groups and to be able to add value to those discussions. You know, maybe I'm kind of putting solutions before problems here, which is a bad thing to do. But in my mind, that's where I see this going. Yeah. Be a lot more inclusive, a lot more easily and more efficiently through the use of these platforms in those discussions, getting that information out, receiving that information in. Which is not a kind of, you know, somebody sat there in front of a web page, typically, you know, submitting information.
Yeah. I mean, I think from a lawyer's point of view, they like to keep things tight, you know, having discussion groups and, you know, even unsecure emails just without a password, or a text message without a password, you know, we tend to try and keep things. So these platforms really work. So if for example, you could say, well, there's a text message just said there's an update, log on, you know, that kind of thing. So because security is a big thing for lawyers, firms, obviously, you know, and the confidence of knowing that it's only your client that is likely, you know, is going to see this material, I think is really important. So I think there's a, you know, it's great to use all these new things, WhatsApp and all the rest of it, but I think it does come with its challenges from a risk point of view.
No, absolutely. I mean, call to action, email call to action is the simplest form, isn't it? You know, log in for want of a better term, come and find out more information. There's an update, you know, that's a starting point. And if that's generated automatically and based on kind of context or triggers, then it's not somebody needing to do that. You're kind of, you know, keeping the discussion going, essentially.
And Neil, how do you see the funding market evolving for group claims? And what do you, I guess you mentioned a lot of your firms are self-funded, but maybe Mark might be better for this. What do you see as criteria that funders are looking for from firms?
So, I mean, to some degree, it's not that different from any non-group claims, which is, you know, what's the budget? What's the likely value of the claims? Are the other side actually good for the money? So, you know, which defendant can we actually pin this on that's likely to be in a position to satisfy any judgment or settlement? And then what are the actual legal merits? Are there any issues around things like jurisdiction or limitation or any other concerns that we need to address? But I'd say that's the main stuff. You know, how much is it going to cost? What's it worth? Is it a good case? And are the other side good for the money? If you can cross those bridges, you're doing okay. The issues we normally see are then, okay, you've identified all of those things. How do you then build a group big enough to say get to that quantum level that justifies the budget that you've got? And you can get in a little bit of a chicken and egg situation of, you know, you need funding to build a book, but actually funders would prefer to see that you've got some kind of book that has value there before they're interested in funding. So I think if you're not willing, or you don't have the capacity to get your book off the ground before engaging with funders, then you need to create a fairly compelling reason why the funder should be financing this book build from scratch. So they're going to want to know, if, you know, is this a competitive landscape? Are other people going to be book building in this space? If they are, what makes us think that we can get enough in our book build to justify the expenditure and the cost of doing so? If there are concerns about, you know, being a particularly competitive landscape with other potentially other funded groups out there book building, then I think you're going to find it pretty hard to get someone to come in from scratch and do it. You're probably going to have to find either, you know, claimants willing to invest some money, or perhaps put some time and effort in between yourself, counsel, experts, maybe, to actually just get something off the ground before you engage with funders. But one of the things we've always done with clients is have discussions from a very, very early stage. So, you know, if people are identifying what they think are interesting opportunities to go out and explore a market, explore a group that they think they could get off the ground, actually talk to them and find out, you know, what the potential is for the market, what they think they can bring to the party, and really discuss, you know, what type of work might need to be done in order to attract early case funding. Because what you can't do is just go out, you know, think of it as a kind of Dragon's Den style opportunity. You can't just go in front of funders with some half-baked idea that you haven't really put full thought into. You're going to have to put some effort around identifying what the market could be, what type of budget you're going to be looking at, what potential retainer you might use. So are you looking for every single penny of your fees to be funded, or potentially, you know, half your fees funded and the other half at risk? You know, who are the defendants we're likely to be going after here? You know, is it professionals with insurance? If it's not, where are they based? If they're in offshore jurisdictions, are the assets likely to be in offshore jurisdictions? Do we know what types of jurisdictions they might be? How easy is it going to be to enforce and recover against any judgment? Just putting some kind of basic thoughts around, you know, what is the project? You know, the way to think about litigation funding, and indeed in insurance, is, you know, this isn't borrowing, this isn't lending, this isn't money you're going to be paying back come what may. These are really joint venture opportunities. You know, you're asking for a partner to come in and work with you on a joint venture whereby you do the work, they take the risk financially, and at the end of it, hopefully there's some kind of profitable project that you can share in those profits.
Yeah.
And it's been worthwhile for everybody, you know, claimants, legal team, and funders or insurers. If you're looking for a joint venture partner for anything, you know, really you want to be able to convey to them, what is the commercial opportunity here that you're asking them to get involved with? What type of risk are you asking them to take in terms of kind of the size of their investment and how risky that investment might be? And ultimately, how do you realize some kind of profits from this activity that allows everyone to benefit from it? And if you don't think you could go in front of your own partners in your law firm and convince them that this is a good idea to be getting involved with and spending some of the firm's money to do it, you know, if you don't think you're in a position to do that, then you're probably not in a position to convince an external funder to do so either. So I would just think about it like that whole Dragon's Den thing of, you know, how confident would you be in going in front of a group of people and saying, this is a good commercial opportunity and these are the right reasons why you should get involved? And what types of questions would you be asking if you were sat in one of those chairs being presented with that opportunity? And you'll probably find that if you can convince yourself in a mirror that it's a good idea, you may well be able to convince other people it's a good idea too.
Yeah, it's not too dissimilar, I think, from you know, a small startup organization pitching for their seed or their VC funding, essentially, is it? You know, it's exactly the same process. The attributes are slightly different, obviously, but
yeah, absolutely.
like it's, you know, it's exactly the same process.
Well, the terms I put it in is property, you know, because if you're being approached by individuals, one thing everyone's familiar with is kind of property, you know,
Yeah.
and land. And like, look, you know, if you've got a big garden and your idea is like, I could build some flats at the end of this garden and sell them on, but what I want is a joint venture partner to come in and spend all of the money scoping out this project, then building the flats and then selling them and bringing in the money. But obviously it's my land, so I want to keep all of the profit, really. You know, that's probably a pretty tough sell. If you've gone out there and gone, right, I've done some research about what this land's worth, what we might be able to build there, what kind of permission we could get, what it could cost to actually build those flats, and what the market in this area would allow us to actually sell them for. So I've actually thought this through as a bit of a kind of business plan of what we can do here. And now I can go out and I can attract investors based on that commercial opportunity. You go, well, that sounds to me a bit more compelling and something where potentially you could get a good deal on that. But if you're going out there just going, look, you know, I've got some land and I've got an idea, then that's a pretty tough sell, I think.
Okay. Stu, I'm not sure, you mentioned you wanted to save a couple minutes for some of the Q&A.
Yes, indeed. Yeah. And I think this might be a good juncture for us to have a look at that now. So we've had some that came in the run up to the event. The first of those is, does any of the panelists have, and this kind of rolls on actually from what Mark was saying about this being a pitch, you know, when we're looking at the technology and how to pitch that to partners, are there any real sort of key tips and highlights that any of the panel would suggest from their experience is a good thing to focus on?
Focus on the benefits. Don't pitch the technology, pitch the benefits that you will deliver, by adopting that technology. I think, you know, people get too focused on great bit of kit, great feature, wouldn't it be great if, but certainly when pitching that up and out, look at the value it delivers, be it time to market, be it reduction in, you know, case handlers that need to support this case, whatever it may be. Take those benefits and where possible demonstrate, I would say, those benefits as well.
Yeah, I think that's absolutely right, and I think also, I think if partners may be fixated on that specific case that you're pitching on, because we are asking to develop this product, this platform to deal with this case, but obviously once you've built it, once you've got that platform, then adjusting it and changing it, and you can using it on other cases. Once you've experienced it, and once you've got that capability, I think it creates other opportunities. So it's not just about, just don't pitch it as just that case. This is a strategic thing we need to be doing for other cases moving forward.
Yeah, I think getting an understanding of the stakeholders as well. So, you know, if you're the partner, you know, you might be a little insulated from maybe what goes on with the intake staff and things like that. So maybe, you know, you have an understanding of their processes, but maybe not the day-to-day issues that they get. So I think getting someone involved that, you know, does something like that on the day-to-day, even if it's just on the initial call when you're evaluating the technology, is really important to understanding not just maybe the hard cost savings, but the soft costs that you're getting out of technology that you may not see from a 3,000 foot view.
Great, thank you. We've also had a question which is, how do you find the right technology for your law firm? Now, I suspect that's probably a bit of a strange question to ask you chaps, seeing as you're very specifically dealing with your product. So of course, you know, the short answer is yours is the best one. But
well, I'm independent.
Yeah, so perhaps Neil, you can start us off with your journey in terms of finding technology and what you looked for and etc. and how you evaluated it.
I mean, I think I mentioned this earlier on. We'd seen a lot of different products, did lots of different presentations, and you've got to find what's right for you and look at what solutions you want. As I said earlier on, lots of the things that we saw dealt with elements of the process, but not onboarding through to completion. And that was one of the attractions of this FinLegal offering, was that it was one, you know, system from start to finish, which covers everything. So that was good. And I think it's just about, you know, finding the people you think you can work with at the end of the day. So I think it's having a good look around at what's out there, and then coming to FinLegal. I'm not being paid, honest.
I think, you know, there was the word tech again in that question, Stuart. It's not just about the technology as well. Neil said, who can you work with? It's about the team, yeah, and the partnership to deploy that. So don't get hung up on the tech. Make sure you understand your goals, what problems you're trying to solve, and do your due diligence. That there'll be different offerings from different places that do different things. We've said that all along. It's about getting what's right for you, really.
Yeah, great.
Yeah, and Timo mentioned it earlier. You know, I think it's all about solving problems, right? You know, flashy features and solutions are great, and, you know, sound great on an email and when you're looking at them, but to get an understanding of what issues that your team is facing, or how, you know, maybe the issues with scaling, book building and things like that is, you know, the most important thing when evaluating technology and for something like this.
Brilliant. Thank you very much, guys. We've got an oddly specific question that's probably slightly off topic from what we've been talking about today, but perhaps some short soundbite answers from our panel just to give it insight. The question is, do you feel the current laws governing artificial intelligence are too stringent, or could we legislate more given the rise of models such as ChatGPT, especially in the realms of IP law and beyond?
I think it's too soon to answer that question, Stuart. It's, you know, it's nascent, it's growing, it's evolving. We don't fully understand the capabilities. You know, why are we legislating? Is it to protect? Is it to enable growth? All of these things are relevant. Yeah, personally, big space. Too soon to say whether we've got it right or not. What we should do, we need to look at how the end users evolve. You know, there seems to be a fixation on ChatGPT right now, but how is that really being used in this space, for example, and understand the implications of that before we start and think how we maybe turn the screws on legislation, in my view.
Yeah, I think it's probably a very broad question to try and cram into a very short section. I think that's it. Yeah, that could be a day's conference in its own right, I think.
Yeah.
Brilliant. Well, I'll move on to the last question, which is just how do you ensure proper integration of your systems? Now, I assume by that question it is, how do you make sure everything you've got that you're using in your technology stack is talking to each other properly and not creating extra hassle?
Oof, okay, so I mean, obviously, system integration starts with the problem. What are we trying to do? Are we trying to, you know, verify accuracy of data or something like that? So we start with the requirements. We understand the roles of the different solutions. So what do we do at FinLegal, for example? What do we rely on our identity partners to do, and make sure we're very clear and how we build that in our into our kind of workflow and logic. There's obviously then the build and the execution of that, which is probably the boring bit. And then you know, to make sure it's working from our point of view, we have a suite of observability tools which are checking these things on a per second basis to make sure that our customers, you know, and their clients aren't subject to any integration issues, for example. So that's making sure we've got kind of the audit checks in place end to end, making sure the interfaces are up and working, and the associated support processes that go with that. So I'm not quite sure if that answers your question, but that's a nutshell view on that one.
Yeah, I think so. Again, the integration of different systems and technology will be case by case, I suppose, won't it? Depending on what it is you're trying to plug into one another. You know,
yeah, we try to, you know, reuse. So, you know, if it's particularly around identity or vehicle data in a particular region, then, you know, we'll try and from our point of view, work with one or two providers that we can then manifest throughout our kind of customer base. So they're getting not only that expertise, but also the value of scale, if you like, in that integration. And then, yeah, to do that, we follow the process just described, essentially.
Brilliant. Well, I think that's all we've had in terms of questions. So I think all that remains is me to thank our panel on behalf of all the BLS members and attendees. for coming along. Remind everybody that the webinar will be available on recording at some point in the future. So please do check back if there's anything that you want to refresh your memory on, and to direct you to the Bristol Law Society website, where we have a list of all of our upcoming webinars, and you can decide which of those tickle your fancy. But thanks all for attending, and thank you very much to our panelists.
Thanks a lot. Cheers.
Thank you.
Bye.